All rise. The Court of Appeals, Division 1 is now in session.
Please be seated. Good morning. We are here for oral argument in our case number CV 220632, American Federation versus the City of Phoenix. Each side has 20 minutes for your arguments this morning. Appellant may reserve some time. I would just ask that you keep track of that yourself. You know the gig. Our proceedings are being audio and video recorded, so if you can introduce yourself and your client, that would be appreciated. We've read the brief, discussed the case at conference, and are familiar with the arguments raised. And so with that, counsel, you may proceed.
May it please the Court. Your Honor, I'd like to reserve about 5 minutes for rebuttal, if I may, and I'll try to keep on task for that purpose. As we pointed out, there are a couple of general observations I'd like to make before I get into the weeds. First of all, my name is Dan Bonnet. I'm with the law firm of Martin & Bonnet here in Phoenix, and we represent the appellant here, the American Federation of State, County, and Municipal Employees, Local 2384, which I'll refer to simply for brevity's sake as the union, or perhaps 2384. There are two issues we raised in our appeal. The first has to do with a construction of relevant language in the City of Phoenix Meet and Confer Ordinance, which I'll refer to just simply as the ordinance. And the second is whether or not the Phoenix Employment Relations Board, or PERB, acted in an arbitrary and capricious manner in rejecting the findings, recommendations, and conclusions of its own hearing officer with regard to the unfair labor practice, or the ULP. I don't think the second issue is particularly one that's probably going to be the focus of the issues that we have to decide, because we don't get to that second issue technically unless we have a clear understanding as to what is meant by the meet and confer provisions of the ordinance. So as we pointed out, we think that this is a matter of statutory construction. The standard review for the court here is, the court is aware, is de novo. And looking at the language, the pertinent language in the statute, it's the union's position that insertion of the phrase "on all economic matters" in section 2-21011 of the ordinance is really outcome determinative of whether or not there's an ongoing obligation to meet and confer under the ordinance, given that restriction. I had a conversation when I was arguing the Wade versus Arizona state retirement system with a colleague, Paul Bender, Professor Bender at the University of Arizona Law School, about preparing for that argument, and he helped me focus in that case, as I think is equally applicable here. When the governing body, the legislature or the city council, chooses words to insert in an ordinance, they must do that for a reason. They don't just blindly insert words and phrases. And so the city obviously had some reason to insert in that section of the ordinance a temporal limitation on the meet and confer process before the deadline for, under state law, for submitting a tentative budget as it relates to economic items. If they intended to have a hard stop, as the lower court determined and as the city would have this court believe, on all meeting and confer, there would be no reason to insert that phrase in the ordinance. So they must have had a reason to do that. And I think it's important to understand the backdrop against which that ordinance was adopted in 1976. It was premised on, and this court has recognized on at least 3 separate occasions involving these same litigants, in 1985, again in 2004, and again in 2006, that the derivative portion of the ordinance, at least for purposes of what we're here today to talk about, had their genesis in the National Labor Relations Act, which was passed under the Wagner Act by Congress in 1935, was amended by Taft-Hartley in 1947. So when the ordinance was adopted in 1976, the council knew full well what terms about collective bargaining meant. And we did a side-by-side comparison in our reply of what bargaining means under Section 158D of the National Labor Relations Act and under Section 2-21011 of the ordinance. And the operative language is essentially the same. So the city had the benefit of congressional legislation, which it patterned the ordinance after, and 30 plus, almost 40 plus years of developing labor law by federal courts, determining what those phrases and what those terms and conditions meant. So I think it's important as a backdrop to have that sort of genesis in understanding what was meant. If the city council wanted the ordinance to say all collective bargaining, all meeting and conferring stops when the memorandum of understanding is approved and ratified by the parties, it had every opportunity to say that in the ordinance.
Didn't it say that? Didn't it say that, and didn't your client agree to that in the memorandum of understanding? What do we do with that, or what role does that play?
Only in certain contexts, Your Honor. I think it's in the context of bargaining for something that came up anew, trying to engage in some meeting and conferring on a substantive matter that was never addressed during the collective bargaining process. And I think, again, it's important to understand why that phrase, on all economic items, exists. And we pointed this out in our opening brief. The city has a financial obligation to deliver the promises it makes under the collective bargaining agreement to all of the bargaining units. There's a dollar cost to that, and that cost is finite. And once it's determined, it has to be incorporated in the budget. And that makes sense why that phrase, all economic items, appear.
There's a term in the MOU that I'm not sure either side has really focused on, and that's 6.7D. And it says in sentence 2, the union, having had an opportunity to raise all matters in connection with the meet and confer proceedings resulting in this memorandum, is precluded from initiating any further meeting and conferring for the term thereof relative to matters under the control of the city council or the city manager. So I think, doesn't that address your argument where maybe certain matters were carved out from the MOU?
Only in part, Your Honor. And if
all matters seems pretty broad to me.
Well, only in sense of the bargaining for the economic aspects of this. That language was addressed in other cases as well. In fact, if we go on and look a little further in the section 6-7B of the ordinance, there's a specific language in there that talks about recognizing the ongoing obligation to continue discussions in an effort to resolve disputes. So there's two aspects, I think, to meeting and conferring here that we really need to sort of try to focus on. One is, once there's an agreement, it just isn't the end of the process. There are issues that come up in the workplace every single day. COVID was a perfect example where the city approached, and rightfully so, the union, and wanted to deal with issues about interpreting language under the existing MOU. And that happens, and that's true in every labor setting, whether it's in the private or public sector. There's this ongoing meeting and conferring concept about administering the rights of the parties under the agreement. And if we embrace the city's position here, they could simply say, we don't have to talk to you about that. And I think that's contrary to the purpose under 2-294 about working together to make sure the services that the workers in the city deliver to its citizens are consistent. So this is not an MOU grievance. This is about what that section of the ordinance means about the obligation to meet and confer on non-economic items.
So, counsel, you just said there are issues that come up in the workplace every day.
Correct.
How far does this meet and confer provision extend in your mind to these issues that come up every day?
It extends to non-economic issues if the union wants to have a position to let management know what's probably smart or probably not smart.
So it's the
and that's
union,
talking. It doesn't mean...
Counsel, so it's the union that decides what needs to be met and conferred about?
No, bargaining's a two-way street, Your Honor.
Okay, so let's ask the question again. How far does this meet and confer extend? You just said there are issues that come up in the workplace every day.
The court this court already addressed that issue, I believe, in the 1985 decision, where it said, quote, "The meet and confer ordinance is a procedural vehicle designed to foster an exchange of ideas between city management and its employee representatives," unquote. That's what we're talking about here, is exchanging ideas on non-economic matters after the issues arise. So if the union or the city says, you know what, we've got an idea here we want to talk to you about, that is engaging in discussion. This court and other courts have recognized, including the Supreme Court, that that doesn't mean in the public sector that the union can say, well, it's our way or we're going to strike. There's no strike clause here. It just means talking about things that make sense so that management understands labor's position and labor understands management's position as it relates to the delivery of these services. So that's how far it goes, Your Honor. It's going to be specific depending on the circumstances.
I'm not sure I got the answer. So, not the case. Is it a material non-economic matter? Is it any non-economic matter depending on the union or the city's position? What is the standard that you would want us to interpret the scope of this meet and confer as?
I don't think this court needs to decide a bright line standard. I think that's for the trial courts. I think initially that's probably for PERB, in PERB's purview. If the union feels there's an unfair labor practice, they file an unfair labor practice charge. We have a hearing like we did in this case with a hearing officer who makes a determination whether this is indeed an economic or non-economic matter. It has to be developed on a case-by-case, full factual record. So I don't think it's necessary to adopt a standard here that suggests a bright line rule.
No, you want us to find that this retention of an outside Felix, whatever, third party is within that meet and confer.
I don't think so, Your Honor. I don't think we've asked that for that relief. I think the relief we've asked for here is to find that meeting and conferring is not foreclosed for the appropriate level of decision maker to make a determination whether this is an economic item or a non-economic item. If it's an economic item, that's the end of the discussion. If it's a non-economic item, then it's up to other fact finders to determine whether or not there's an ongoing obligation to, under MP 5.501 in this case, invite the union to sit down and explain why it makes sense or why it doesn't make sense to have these services performed by an outside contractor. We acknowledged in the lower court, and we acknowledged before PERB, there may be statutory requirements depending on the size of the project, where there's an affirmative obligation to contract these services out. But there are certainly obligations, and there was testimony in this case in front of the hearing officer that there were aspects of the work that could have been done by members in the bargaining unit because they had been doing it all along. It was within their job description. So you're paying Joe Smith 40 hours of work at, say, $35 an hour to perform a task. Why not have him do that task as opposed to standing around and doing it? It doesn't change the economic outcome. It doesn't change what the city is spending. So I think, again, the real issue here is what does that phrase mean? And if it means
that phrase being
non-economic, on all economic items.
Well, what do you think it means?
I think it means exactly what it says. I think it means that on non-economic items, there's an obligation on the part of the parties to listen to the other parties' positions about any issue that has to do with wages, hours, and working conditions, and contracting out, the Supreme Court has said, U.S. Supreme Court has said, is certainly a matter that affects the working conditions of the parties. So I think, again, we don't need to go as far down the road as I understood your question to be directed at. I think it's more of a question is what does that mean? And if it means what we say it means and what it appears the city council said it means, then it's for other parties on a case-by-case basis to make that determination whether or not it's an economic item or a non-economic item. In this case, if the union had been invited to the table and sat down and talked with the city about whether this should be contracted out, at the end of the day, we acknowledge the city could have said, you know what, your ideas make perfect sense, but so what? We're not going to do that. We're going to go ahead and contract this out. That's not what this is about. At the risk of sounding a bit zen, it's about the process. It's not about the outcome. And the process here is, if there's a smart, sensible, economic, productive reason that the labor can offer to the city why something should be done, one would hope that the idea would stand on its own merit, not who the proponent is. And so,
Is there any information, or is there a document in the record showing how this particular meet and confer process was initiated or attempted to be initiated?
I think the record reflects that the city let, the prior president of the local found out by looking at the agenda for the city council that there was a job order contract for Felix that was up for approval of $20 or $45 million. I don't remember what lot amount of money. That's how he found out about it, after it was already on the agenda.
But then someone must have reached out to the city to say, we want to meet and confer, and I guess what I'm interested in is, what did they say they want to meet and confer about? How detailed was that?
They wanted to be heard about why it made sense to let some of the Unit 2 employees do the work, because one of the cardinal rules of any labor organization is you keep your work, because if you lose your work, you lose your members, and you lose your members, then the basis for existing is not there any longer. So that was the process. They reached out to the city to say, we want to have a seat to talk about this before you actually start having Felix do the work. And that's consistent with the concept of trying to resolve disputes. That's consistent with the ongoing administration of labor management relations. I'm going to run out of time here, but let me just leave you with one last thought. Part of the problem here seems to be that, I'm going to be a little philosophical, which is always dangerous, is that people tend to stop talking to one another, and worse yet, they tend to stop listening to one another. And the idea behind collective bargaining is, and particularly in this context, is listen to what the other side's position is. You don't have to agree with it. You don't have to accede to it. In fact, the ordinance specifically says you don't have to give up anything if you don't want. But through that exchange of ideas, hopefully a better service can be delivered to the citizens of the city, and that's really what the union's position is here. So I'd like to reserve the 3 minutes and 30 seconds I have left for rebuttal, if I may.
Council. Can you put it back to 20, please?
Good morning, and may it please the court. I'm Andrew Pappas of the Osborne Maladon Law Firm, and I'm here on behalf of the City of Phoenix. Your Honors, the question in this case is whether the meet and confer ordinance or the parties' memorandum of understanding requires the city to meet and confer with the union before contracting out work. The answer is no. Neither controlling document imposes such an obligation, so the city has no such obligation. The union's claims fail as a matter of law, and this court should affirm. The ordinance doesn't require the city to meet and confer with the union before contracting out work. Under the ordinance, meeting and conferring is a term of art. It is not simply saying, we have an idea that we want to talk about, or talking about things that make sense, as my opponent just asserted. It is a term of art defined by the plain terms of the ordinance itself. It has a specific, limited meaning. It is the process by which the city and the union negotiate a written memorandum of understanding. Here, the city and the union did meet and confer. They agreed on an MOU. And that MOU, as Judge Catlett pointed out, specifically addresses the issues in this dispute. It specifically addresses contracting out. In Section 1-3I, the MOU references a management procedure and requires the city to notify the union of the city's intent to contract out work. But it does not expressly require the city to meet and confer with the union before doing so. And Section 6B of the MOU says that unless the MOU expressly requires it, quote, "the city shall not be required to meet and confer concerning any matter, whether or not covered herein, during the term or extensions thereof." That should be the end of the matter. But if there were
You
any...
say that the term meet and confer is a term of art, but
Yes.
it's also a defined term in the ordinance,
Yes, it is.
which says meet and confer is the performance of the mutual obligation, and it says who has the obligation to meet, and then it says to, quote, "meet at reasonable times." That's it. I mean, that seems to support the union's position that there is some obligation that when it asks, and if it's being reasonable, that the city's required to sit down and talk.
Your Honor, if the definition ended there, then I might agree, but it doesn't. It goes on. It goes on to make clear that meeting and conferring includes the execution of a written memorandum of understanding embodying all agreements reached. And the ordinance also includes a bunch of temporal limits, deadlines. It says when meeting conferring can occur. It can occur in any year in which it's authorized by the ordinance or the terms of a memorandum in effect pursuant thereto. It has to begin on December 1st. There are some intermediate deadlines. And then we know also from this process that's laid out in the ordinance that it ends with the execution of a written memorandum of understanding. And again, we have such a written MOU in this case. The MOU addresses contracting out. This isn't simply some issue that no one thought about. It's an issue that the parties specifically bargained about and reached an agreement on. And having done so, the union is precluded from initiating further meeting and conferring. And the city is not required to do so. And in the absence of an affirmative obligation to meet and confer, there can be no unfair labor practices charge, which means that the union's claims have to fail as a matter of law as the Superior Court determined. Your Honor also pointed out that provision in Section 6.7D of the MOU. And Your Honor read it correctly. It says, "The union having had an opportunity to raise all matters in connection with the meet and confer proceedings resulting in this memorandum is precluded from initiating any further meeting and conferring for the term thereof relative to matters under the control of the city council or the city manager." My opponent tried to limit this to economic items. That phrase is nowhere to be found in Section 6.7D. It's nowhere to be found in Section 6.7B, which I previously read. It says, "Except as expressly provided in this memorandum, the city shall not be required to meet and confer." And then if you look at the section on contracting out, which is Section 1-3I, that phrase "meet and confer" does not appear in Section 1-3I. So there's no argument that the parties expressly agreed that the city would meet and confer before contracting out.
Do you agree that this particular meet and confer request addressed a topic that is within the current MOU? Yes, and I was asking counsel where in the record I might look to see exactly what the contours of this request were.
Well, Your Honor, I mean, we're here on a motion to dismiss, of course. So what we've got is the complaint. My opponent said that the union learned about it through a city council agenda, but if you look at the complaint, paragraph 12, which they cite in their brief, they say that on or about April 10th, 2020, without any prior attempt to meet and confer with the union, the city advised plaintiff that the city had accepted a bid and entered into a JOC and so on. And then they say in paragraph 14, upon learning these facts, the union demanded the city meet and confer in good faith on a mandatory subject and so on and so forth. But it doesn't really detail what the demand was. Our point is simply that what the union is describing is not meeting and conferring. Maybe it sounds like that in some colloquial sense. I mean, even as my colleague described it up here, they want to get together and talk about ideas. That's not meeting and conferring, because meeting and conferring is a specific process ordained under the ordinance that leads to the execution of a written memorandum of understanding, as this court recognized in the very 1985 decision that my colleague cited.
I think the union would say, well, that's what we wanted to do. We wanted to sit down, we had a problem with this project, we wanted to sit down with the city, and we wanted to come to some sort of agreement about what this might currently look like or what it might look like in the future.
Well, Your Honor, what they're describing, and even I think what Your Honor
I
has...
guess, yeah, did I just describe meeting and conferring or something else?
I don't think so, because when you've got an express term in the MOU that says, here's how we're going to deal with this thing when it comes up, if the union isn't happy with how the city has dealt with it, or if the union thinks the city has violated the terms of the MOU, then there's a grievance process. And the grievance process is different from the unfair labor practices charge. They have different dispute resolution mechanisms. And again, this is something that the parties thought about in advance. It was something that was in previous memoranda of understanding. So the union wasn't trying to come up with a new, and again, all we can go on is what's in the complaint here. But even by my colleague's description, they weren't suggesting, a new memorandum term or something. They're complaining, as I understand it, that the city didn't follow the process that's laid out in the existing memorandum. That is not an unfair labor practice. That is a grievance. They have cited a number of times the section of paragraph 67B of the memorandum that says that the city has to continue to meet with affirmative willingness to resolve grievances and disputes. Fair enough, but resolving grievances and disputes is different than meeting and conferring. We know that, I think simply as a matter of statutory construction. It's right below the paragraph in 67D that says that except as expressly provided herein, the parties shall not be required to meet and confer. So the memorandum itself distinguishes between meeting and conferring on the one hand, which again is the process by which a memorandum is executed, and the grievance resolution procedure, which is detailed in the MOU. The ordinance contemplates that the MOU will set forth a grievance resolution procedure, and the parties did that here.
The ordinance in section 2-20, the actual section that talks about unfair employee relations practices, says the public employer is prohibited from, and then number 5 is refusing to meet and confer with an authorized representative of the employee or employees, provided, and then there's a carve out for the economic items. That seems like a pretty clear statement, and I think at least just taking that here, they wanted to meet and confer, the city refused to do so. So that tells me that, that's a violation of that provision. I think your response will be, well, there's other context that we need to consider in the rest of the ordinance.
Right.
And so I have a question about that, because section 2-235, which is a similar prohibited practices section, I'm not sure if you're familiar with it.
2-235?
Right.
Let me take a look at it, Your Honor. Is this in the 2-2?
It's the meet and discuss.
The meet and discuss, okay, yes, which doesn't apply here.
Right, I understand that,
Yeah.
but number 4, so 2-235A4, it essentially says the employer is prohibited from, and 4 says refusing to meet and discuss with representatives of an authorized employee association as set forth in this division. And I think as set forth in this division shows me that when the city wants to bring in the other context, it does that, but it didn't do that in the meet and confer provision, and so I was hoping maybe you could address that or respond to it.
Sure. Well, I guess one preliminary observation, which is that even phrases that sound similar, like meet and confer and meet and discuss, have different statutory meanings within the context of the meet and confer ordinance. So simply because something sounds like one of those things doesn't mean it is that thing. Second, Your Honor, I guess I'm not sure that those words in this division have some particular meaning that would be missing from the meet and confer provisions as a whole. The statutory definitions say that, as used in this ordinance, meet and confer means these things, grievance means these things, memorandum of understanding, impasse, all of these are defined terms. With regard to the provision about refusing to meet and confer about economic items after the budget deadline, the first point, of course, is that saying that the parties aren't required or that they are required to do one thing doesn't mean that they are also required to do something else. That doesn't impose an affirmative obligation to meet and confer about non-economic items. In any event, under the terms of the ordinance, it also doesn't imply that the budget deadline is necessarily the deadline from the memorandum of understanding, or better put, that the parties can continue to demand that each other meet and confer beyond the execution of a written memorandum of understanding. That's really the critical point, Your Honor, is that once there is a written memorandum of understanding that embodies all of the agreements reached in the meet and confer process, meeting and conferring is over. And then the parties have to perform under the MOU. And so here, the question is, does the MOU deal with this particular dispute? The answer, I think, unequivocally is yes. I mean, I think, and I obviously don't want to put words in my opponent's mouth, but I think the union itself acknowledges that the MOU deals with this situation, that the parties bargained over contracting out, that there are express provisions in the MOU that say what's supposed to happen in that instance. And I think once you've acknowledged that the MOU covers this situation, and the question really is, okay, if the city has allegedly violated the MOU, then what's the remedy? The remedy is not an unfair labor practice charge. The remedy is the grievance resolution procedure, which the union and the city agreed to in the MOU. It's not the city that's trying to change the terms of the bargain here. It's the union that's trying to get out of the MOU that it bargained for, and to try to ring the city up on an unfair labor practice charge. I do think a lot of the difficulty here, Your Honors, is occasioned by the use of this phrase "meet and confer" by our opponents to mean something that it doesn't mean in the context of the ordinance. Judge Weinswag asked the question about, well, what are the limits of their position? And I think the answer is there are no limits, at least as concerned non-economic items. If the city wants to change the size of the employee's ID badge, is that something that they have to meet and confer about if it's a non-economic item? I mean, it starts to get rather silly. Of course not. Of course not.
Do you agree that what we're talking about here are non-economic items?
Your Honor,
I know we have an allegation, and I think we have an argument that we have to take that as true because we're at the motion to dismiss stage. But
I think the court certainly could conclude that these are economic items. As I understand it, economic items include things related to the budget. I think that's how the ordinance treats economic items. To the extent it says they need to be ironed out before the budget-making deadline, that suggests that budgetary items are economic. I think the court could make the determination that this is an economic item, but I don't think it needs to resolve that question in order to affirm the Superior Court. I think that the court can get there in a number of ways. One is to say, as the Superior Court correctly did, that the meet and confer process prescribed by the ordinance is a temporary, periodic process designed to culminate in the execution of a written memorandum of understanding, which happened here. And so things that happen outside of that process aren't meeting and conferring. And so what the union has requested here isn't meeting and conferring, it's something else. I think the court can also say the parties met and conferred, they reached an MOU. The MOU specifically addresses this topic. It's not some unforeseen thing that didn't come up. It's a thing that's specifically addressed in the MOU, and that if the union has a problem with the way in which this was done, there's a separate procedure for resolving it. It's the grievance resolution procedure, and that doesn't entitle the union to state an unfair labor practices charge, and so the union's claims fail as a matter of law. I think the court can get there in both ways, but I don't think the court needs to resolve this question about whether it's an economic or a non-economic item. I guess I'd also say, just with regard to the management procedure that my colleague brought up, if you look at the action steps and what are the things that are entailed in this procedure, I mean, step one, evaluate, identify, notify. It doesn't say meet and confer. Step 9, notify. Again, there's no meet and confer requirement. And if you look at who's involved, evaluate.
what's the purpose of notifying then if in response, the union says, you notified us of this, we want to talk about it, and you say, well, we don't have to.
Well, so again, I think the union can say, we want to talk. That's not meeting and conferring within the strict confines of that term.
What I guess what is it then? It's meeting under MPP 5.01?
It's
Is part of
meeting.
the MOU?
It can be meeting. It can be evaluating with the team, which is what MPP 501 says. And that, by the way, that's different from the meet and confer process too, because it involves people other than the city manager's designee and the employee representative, which are the parties designated in the ordinance to meet and confer. So we know it's not meeting and conferring. And the parties in the MOU have agreed to all kinds of things that are different than meeting and conferring. I mean, they've agreed to consult, for instance. They've agreed to meet. They've agreed to establish meetings. They've agreed to do all kinds of those things. But they have, in fact, agreed to meet and confer about certain things where they've wanted to do so. The court can take a look at the savings clause. This is 6.1 of the MOU. It says, if any article or section of this memorandum should be held invalid, the parties upon request of either of them shall meet and confer to endeavor to agree on a substitute provision or that a substitute provision is not indicated. So again, the parties know how to say that they want to meet and confer. They've also said that unless they expressly provided that they are required to meet and confer, then they're not required to do so. And so in the absence of that phrase in section 1-3I, the contracting out provision, there's simply no requirement to meet and confer. And I realize that at some level all this sounds a little semantic, but the words really do matter here. My opponent correctly pointed out that when a governing body uses words, it does so deliberately. When the parties in their contract specifically agreed that except as expressly provided otherwise, they weren't going to be obligated to meet and confer, that means something. And when they also agreed that the union, having had the opportunity to raise all of these issues in the course of meeting and conferring to come to this memorandum of understanding, is precluded from initiating further meeting and conferring on any issue under the control of the city manager or the city council, they knew what they were doing. And
just real quick, again, you started with the statement that meeting and conferring is a term of art. And
yes.
In figuring out what that term of art means, I think one thing we can look to is where, similar terms might have come from or the history of it, and the union relies on the NLRA. So what's your response to that history?
Sure. Fair enough that this meet and confer ordinance is patterned on the NLRA, but there are significant textual differences between the meet and confer ordinance and the NLRA. If you take a look at section 8D, for instance, of the NLRA, which contains this similar language about collective bargaining, there's a bunch of stuff that comes after the phrase provided, however, that doesn't appear in our meet and confer ordinance. It sets forth a whole different process that doesn't exist here. Likewise, the NLRA, as far as I'm aware, doesn't contain the kinds of deadlines that the meet and confer ordinance does, the beginning point, the intermediate deadlines, the end point that says that it ends with the execution of this written memorandum of understanding. So fair enough that it's patterned on it, but it's different in significant ways. And of course, it's the meet and confer ordinance that governs here, Your Honor, not the NLRA. It's the meet and confer ordinance and the parties' memorandum of understanding that they agreed to that disposes of the union's claims in this case. Those are the reasons why this court should affirm the Superior Court's decision.
Thank you, counsel.
Thank you.
Rebuttal.
You're right. Okay.
Counsel, can you begin by telling us why is this not a matter more appropriately suited for the grievance process as your opponent suggests?
This court addressed that very same argument in the 2004 decision. The 2004 decision, the city came here and made an argument that two employees had to make a decision whether to appeal their discipline to the Civil Service Board or appeal it to the PERB under the auspices of there being an unfair labor practice because the city violated their Weingarten rights. In that decision, this court said those are not mutually exclusive remedies, and that's exactly what the situation is here. The grievance process ends with the city manager making a unilateral decision whether to uphold the grievance or not. There's no independent board, and in that process, the grievance process does not allow for the city manager to make the determination whether there's been an unfair labor practice charge or not. He doesn't have the jurisdiction to make that determination. That rests exclusively with PERB. Conversely, PERB doesn't have the jurisdiction to make a determination whether there's been a grievance violation or not. They're mutually exclusive remedies, and there could be a grievance violation and an unfair labor practice. There could be a grievance violation, no unfair labor practice. There could be an unfair labor practice and no grievance violation. And that was exactly the issue that was confronting this division in the 2004 decision with these same parties. So I know that's a lot.
I guess, yeah, that makes sense to me, but why does this then not fall into the second category where you said you can go to the grievance process but not the
Because the grievance process has no jurisdiction to determine the existence of an unfair labor practice. They can't make that determination. And as this court said in 2004, the parties under the ordinance are not required to waive their rights to determine whether there's been an unfair labor practice.
Don't they have jurisdiction to determine whether some provision of the MOU is violated?
PERB does not have that jurisdiction. They have a jurisdiction to determine whether there's been a violation of the ordinance. I'm going to run out of time. I really wish I had the 5 minutes to address some things, but I want to direct a couple of answers to a couple of questions. First of all, in response, I don't think I did a direct job of answering your question, Judge Weinswig, on the parameters of what this means. Section 2-215A of the ordinance defines the difference between mandatory and permissive subjects of bargaining. So that is the outlier provision that determines where there is an obligation to bargain on something that is a mandatory subject to bargaining. Those are things found in the MOU.
You said
2-215A.
Okay.
And so that's the remedy. Also, in response to your question, Judge Catlett, we talk about the zipper clause in our briefing. In response to that, I think it's important to also take a look at the language that the city omitted from its brief under Section 6-7B of the MOU that says, however, the parties will continue to meet with affirmative willingness to resolve grievance and disputes relating to wages, hours, and working conditions without affecting the terms of this agreement. So it doesn't foreclose there being discussions, and that's exactly consistent with the language that's in the ordinance. And so if we look at the dual purpose under 2-21011, meeting and conferring, and reaching an agreement, then I think we have two prongs here that we need to be looking at, and the city focused simply on the second prong. There has to be an MOU, and it's far more expansive than that.
Okay.
We'd ask the court to remand as requested.
I appreciate that, and thank you both for your excellent arguments this morning. We will take it under advisement, have a decision issued in due course, and we're going to recess now to let the parties get ready for the next argument.
Thank you, Your Honor.